criminal force. It is also known as battery in English law or law of torts. Criminal force is dealt under section 350 in IPC. According to section 350 of IPC, a person is said to use criminal force to another in two ways: by using force intentionally without that person's consent to commit any offense or to cause injury or annoyance to that person. ഒരാളുടെ കൺസെന്റ് ഇല്ലാതെ അദ്ദേഹത്തിൻ്റെ മേളിൽ ഡിറക്റ്റ് ആയിട്ടോ ഇൻഡിറക്റ്റ് ആയിട്ടോ ഇൻറ്റൻഷണൽ ആയിട്ടുള്ള ഫോഴ്സ് അപ്ലൈ ചെയ്യുന്നു. അത്തരത്തിലുള്ള ഫോഴ്സ് അപ്ലൈ ചെയ്യുന്നത് either to commit an offense or to cause injury or annoyance to that person. Four essentials require to constitute an offense of criminal force. Number one, intentional use of force to another. The application of force on another must be intentional. Number two, force may be exercised directly or indirectly. The force which is applying on another may be direct or indirect. Number three, such force is used without the other person's consent. Number four, such force is used in order to commit an offense or to cause injury, fear or annoyance to the person to whom it is used. ഈ ഫോഴ്സ് ആരുടെ മേളിലാണോ അപ്ലൈ ആയിട്ടുള്ളത് അദ്ദേഹത്തിനൊരു ഇഞ്ചുറിയോ അനോയൻസോ ശല്യമോ അല്ലെങ്കിൽ ഫിയറോ ഉണ്ടായിരിക്കണം. These are the four essentials to constitute the offense of criminal force. Let us learn with the help of illustrations. Number one, X is sitting in a mood boat on a river. Y unfastens the moorings and thus intentionally causes the boat to drift down the stream. X ഒരു കെട്ടിയിട്ട ബോട്ടിൽ ഇരിക്കുകയായിരുന്നു. Y unfastens the moorings and thus intentionally causes the boat to drift down the stream. Here the application of the force is not direct, but Y intentionally causes the motion of X and hence he is guilty of application of criminal force. Number two, A is riding a palanquin. B intending to rob A seizes the pole and stop the palanquin. Palanquin means pallak. It's a covered carriage carried by men. So A is riding a palanquin. B intending to rob A. A കൊള്ളയടിക്കണം എന്നുള്ള ഉദ്ദേശത്തോടു കൂടി seizes the pole and stop the palanquin. Here B applied criminal force. Number three, A incites a dog to spring upon Z without Z's consent. Here, if A intends to cause injury, fear or annoyance to Z, then he is guilty of causing criminal force. Thus, in law of torts, in order to commit a tort of battery, direct intentional application of the force is necessary, but in IPC, the application of force may be direct or indirect. Now, assault. Assault is defined in section 351 of the Indian Penal Code. You can write either this definition or the definition from law of torts. All the examples, illustrations, everything is same. We already discussed in law of torts. Only one illustration I want to give to compare between assault and criminal force. A begins to unloose the muzzle of a ferocious dog, intending that he may thereby cause B to believe that he is about to cause the dog to attack B. Here, A has committed an assault upon B. A begins to unloose the muzzle of a ferocious. Muzzle means a cover that which covers the mouth of the dog. Doginte ഒക്കെ വായ് തുറക്കാതെ കവർ ചെയ്യുന്ന തരത്തിലുള്ള കവറിങ്ങിനെയാണ് മസിൽ എന്ന് പറയുന്നത്. സോ എ ബിഗിൻസ് ടു അൺലൂസ് ദ മസിൽ ഓഫ് എ ഫെറോഷ്യസ് ഡോഗ്. ബൈ ദാറ്റ് ജസ്റ്റർ ഓഫ് എ, B aroused some fear in his mind, so A committed assault. When you compare this example with the third illustration of criminal force, there A incites a dog to spring upon B. Direct ആയിട്ട് ഡോഗിനെ ബിയുടെ കൺസെന്റ് ഇല്ലാതെ ബിയുടെ മേലിൽ പായ വിടുകയാണ് ചെയ്തത്. So there A committed what? Criminal force. Now, punishment for criminal force and assault. Punishment for criminal force and assault dealt under section 352 of the IPC. According to section 352 of the IPC, assault or criminal force otherwise than on grave provocation, the punishment is imprisonment for 3 months or fine up to 500 rupees or both. But if the assault or criminal force is on grave provocation, then the imprisonment is for 1 month or fine or both, according to section 358. For an offence committed under section 357 of IPC, the punishment is imprisonment for 1 year or fine or both. For aggravated forms of assault and criminal force, which is dealt under section 353, 355 and 356 of IPC, the punishment is the imprisonment for 2 years or fine or both. Finally, outraging the modesty of a woman, it comes under section 354 of IPC. If a person assaults or uses criminal force against a woman with the intention to outrage her modesty or knowing that he was likely to do so, it is a more serious offence. Section 354 of IPC allows the police to make arrests without warrant, and such a criminal shall be punished with imprisonment for 2 years, which may extend up to 7 years or fine or both. We'll discuss one famous case law, State of Punjab versus Major Singh. In this case, the accused performed indecent acts of unnatural lust to a small child of 7.5 months old, who was sleeping in a room. The accused argued that as the child had not developed sufficient sex instinct, her modesty could not be said to have been violated. ഒരു റൂമിൽ ഉറങ്ങിക്കൊണ്ടിരുന്ന 7.5 മാസം പ്രായമായ കുട്ടിയുടെ നേരെ ഇൻഡീസെൻ്റ് ആയിട്ടുള്ള ബിഹേവിയർ കാട്ടി അക്യൂസ്ഡ് കോർട്ടിൽ ആർഗ്യൂ ചെയ്തിരിക്കുന്നു. ചൈൽഡ് 7.5 മന്ത് ആയിട്ടുള്ള കുട്ടിക്ക് സെക്സ് ഇൻസ്റ്റിങ് ഡെവലപ്പ് ആയിട്ടില്ല, അതുകൊണ്ട് തന്നെ her modesty could not be said to have been violated. Modesty violate ആയിട്ടുണ്ട് എന്ന് പറയുവാൻ കഴിയില്ല എന്ന്. But the Supreme Court held that the essence of woman's modesty is her sex, young or old, sleeping or awake. She is a woman എന്നത് തന്നെയാണ് her modesty. So, even a small child from her very birth possesses the modesty which should not be outraged. ഒരു സ്ത്രീയുടെ മാന്യതയെ ചോദ്യം ചെയ്യുന്ന രീതിയിൽ ഒരു നോട്ടമെങ്കിലും ഉണ്ടായിട്ടുണ്ട് എന്നുണ്ടെങ്കിൽ that is punishable under section 354 of IPC.